Hello, everyone. Thank you so much for joining us again today. It's a privilege to be here, and I'm excited to see everyone. Please feel free to put your video on if you can. My name is Juliana Imam, and I'll be anchoring this session for today, pending when our second moderator is around. Thank you all for joining early. I'll just go ahead to read out what we're about so that we can continue. Our topic for today is intellectual property for creatives, and we have 3 mentors that will be with us today. Gypsy Intellectual Property Mentorship and Internship Program is a quarterly program for students, young professionals, and enthusiasts across Africa. Mentees are afforded the opportunity to access valuable advice, training, network, mentorship, internship, discussion forums, industry updates, and resource materials from experienced mentors. This program seeks to encourage continuous training, development, and evolution in Africa and around the world. You can watch our videos by searching for Gypsy on YouTube and Facebook. Our hashtag is JIIPCCmip. Our objectives are to provide easy access to quality professional guidance, training, and resource materials for students, young professionals, and enthusiasts in Africa to facilitate dialogue and network among experienced and less experienced practitioners and stakeholders, to transform mentees into mentors and leaders for the next generation of mentees, and to facilitate further mentorship, internship, scholarship, and job placements for mentees. Also, I would like to remind us about the private mentorship, and for us to know that most of the amazing mentors that we get to meet with here are people that have subscribed to this private mentorship. So we can have private professional meetings with them for 30 minutes to clarify our paths and things that we want to do. So with that, we'll be going into the presentations for today. For the mentors that will be joining us, I would like to say that you're welcome, and we are so grateful that you're with us today. So without taking much of your time, we'll be going straight into the presentations for today. We have 3 mentors for today that would be listening to the presentations and commenting on them. There's Serenade Phillips. She's an alumni of the University of Pennsylvania Carey School of Law and the New York Film Academy with certificates in filmmaking and producing. She's a New York bar and Nigerian bar certified attorney, posing varied experience in intellectual property law, arts, media, and entertainment law, and projects finance. She has advised on diverse transactions from multi-million-dollar infrastructure projects and transcontinental financial acquisitions to music licensing, film and theater productions, trademark and copyright production and enforcement. As a songwriter and filmmaker, she has a unique perspective and understanding of the creative aspects as well as the business of entertainment. She uses this perspective in advising and advocating for her clients in the various IP and entertainment industry. Our second mentor for today is Mr. Folarin Aluko. He is a legal practitioner and partner in the firm of Truman Brockwood Solicitor, where he provides advisory and consultancy services for companies and a wide range of creators, users, and startups. Mr. Folarin is a director of Intellectual Property Institute Nigeria. He is the chairman board of trustees of the Intellectual Property Lawyers Association Nigeria. Mr. Folarin is a member board of trustees of the Sports Lawyers Association Nigeria, as well as a member of the board of Nigeria Digital Chamber of Commerce. Mr. Luko is also a board member of the Songwriters Association Nigeria with a background in ICT hardware and digital forensic. Mr. Folarin has led legal teams to champion consequential strategic impact public interest litigation in the IP space since 2012. Mr. Folarin is a consulting mediator with commercial intermediates and ADR firm based in Lagos, Abuja. He is a thought leader in Nigeria's innovation, technology, intellectual property, and entertainment space. And our final mentor for today, Bernice. We're excited to have her with us. Bernice Ofuri Essien is the founding partner of Paradigm Stone Attorneys, a business-oriented law firm with a commitment to innovation and reimagining legal service delivery, legal service delivery. She has a passion for fashion and is committed to advancing the development and innovation of fashion industry in Nigeria. She's a certified trademark opposition lawyer and holds a certificate in advanced intellectual property valuation from the Intellectual Property Institute of Nigeria. She's also a member of the Institute of Chartered Secretaries and Administrators of Nigeria and an associate member of the Institute of Chartered Mediators and Conciliators. She further holds a certificate in tax law from the Chartered Institute of Taxation in Nigeria and is currently undergoing her LLM at Babcock University, Nigeria. Thank you so much for joining us. To all our mentors and to our mentees, thank you also for joining us. Please feel free to put your videos on if you can, and we'll be going straight to hear our presentations for today. Please kindly adjust your names. If your description is carrying iPhone, please change it to your name so that it can help with the attendance. So let's hear from Group 1. Who is presenting for Group 1? Please unmute yourself. iPhone is presenting. Who is presenting for Group 1? Please unmute yourself and share your screen and you can start. Okay, if Group 1 is not ready, okay, thank you. Please, you can go ahead with the presentation. You have 8 minutes to make your presentation, so you can start while you're working on the slides. Thank you. Group 1, please, can you start your presentation while the person working on the slide figure it out? Okay, if Group 1 is not ready, I'll just stop their sharing from here and then Group 2 can start their presentation. Okay, please, let's hear from Group 2.
Good afternoon, everybody.
Yes, good afternoon.
Okay, so I'm presenting on behalf of Group 2.
Okay, please go ahead. Who will be sharing the screen?
I will.
Okay, please go ahead.
Okay, so let me just share the screen. Okay. Okay, can you still hear me?
Yes, we can hear you.
Okay, so our topic for this afternoon will be IP protection for creatives. The creatives being fashion, broadcast, and comedy. Introduction. So intellectual property protection is the protection available to creatives and their works, resulting from intellectual activities in the industry, scientific and artistic fields. These creatives include artists, comedians, content creators, inventors, etc. The protection available to them ranges from copyright to patents to industrial design to trademarks protection. So what we're trying to say here is that there are certain protections available to certain people in the industry, basically in the creative part of the industry, that is fashion, broadcast, and comedy. And then the 3 protections that we know that are available for this set of people are copyrights, patents, and trademark protection. So I'll move straight to telling us a few things about the fashion industry in please, are we still together?
Hello, Ma. Sorry, I had network issue. This is Esther from Group 1.
Okay, please just hold on while Group 2 finish their presentation. Thank you. You can continue, Kolawole, please. And please share your slides. Please let me know if anyone can hear me.
Yes, I can hear you, Ma.
Can hear you.
Okay, so Kolawole, are you still presenting?
So, okay. My screen
Okay, I
is
think that Kolawole is having network issues.
okay.
Kolawole. Okay, so since she's not here, please let's hear from Group 1. You can share your screen and start your presentation.
Okay, so my network was very bad. Can you hear me now, please?
Yes, please, who is sharing the screen for your group?
I should be the one, but I don't know what's going on. I'll try sharing it again.
Okay, someone else can also try to share from your group.
Okay,
so you can go ahead.
Okay. So I said we'll be diving into the fashion industry. So the fashion is one of the biggest industries in the world. And according to Fashion United.com, it contributes to about 20% of the world's GDP. We have big players in the fashion industry in the world, such as Gucci, Versace, Louis Vuitton, and then in Nigeria, we have people like Ma Atafo, Yomi Casual, Tiana's Empire, and so on. We have in the fashion industry IP protections that apply to these people in these categories. And under fashion, we can now, bring it down to photography, the makeup part of it, designers, fashion influencers, stylists, fashion houses, and other general fashion entrepreneurs. As we have said earlier, that the certain IP protections that are available for these people are the trademark, copyright, and industrial design, what's it called? Trademark protection. I think we said that earlier. So copyright protection in fashion now. Okay. Please, I hope we're still together.
Yes.
Yeah, we can hear you. We can hear you.
Okay. So copyright in the aspect of IP protects literal and artistic works such as drawing and painting. In this context, we can say it protects the sketch and drawings of designer. So in modern day fashion industries, basically fashion designers, they do their fashion, they create their arts or their clothes or their pieces by first starting with sketches and drawings of a design. So we can say that copyrights can be used to protect those copies, the copies of those designs or those drawings. So another person wouldn't claim them, because you can see that sometimes on Instagram, these artists tend to put up their drawings, tend to put up their paintings of those clothes they'll be creating. So another person can then decide that they might want to, take those things from them. So copyrights will enable them to protect those drawings and paintings from being stolen or taken by another person. So the law in this space protects the IP of sketch and drawing. We said that earlier. So in America, the Innovative Design Protection and Piracy Prevention Bill is used. So there is like a bill that is used in America. Although currently in Nigeria, we don't really have one per se for fashion designers, but then we have the Copyright Act. There is a Copyright Act for basically for everything that needs to be protected under this space will fall under the Copyright Act. And under the Section 1, subsection 3 of the Copyright Act, the work itself must be original, it must be new, and must not be intended to be used as a model or pattern to be multiplied by an industrial process. What it's saying is that for a copyright to be applicable, or for a copyright to be used by a designer, it has to be original, and it has to be that it is personal and not just for use of any person in the public. So moving on, we have industrial design under fashion. So industrial design as a branch of IP deals with the aesthetic aspect of products. It protects the looks of particular products or some innovative design elements of such products. Under the Nigerian Patent and Design Act, for a design to enjoy protection, such design must not have been in the public domain. I think this is clear. The design may consist of 3D features, such as shape of articles, or 2D features, such as patterns and lines. Example of industrial designs could be an ornamental sculpture affixed to a product. For example, if you check Louis Vuitton or Gucci or other brands like that, you see particular patterns, particular designs that are ascribed to those designs or designers. So whenever you see them, you just know that, okay, this design is for this particular fashion designer. So those ones are affixed to them, to those particular designers. So that's what we're talking about there. And under the Nigerian Patent and Design Act, for a design to enjoy such protection, the design must not have been in the public domain. So what we're saying is that it must not be something that has circulated around, that everybody has used it, but something particular and private to such designer. So I've made an example earlier. So there is also trademark protection under fashion. A trademark is a sign or symbol that is used to identify certain goods and services as those produced or provided by a specific person or enterprise. In fashion context, the trademark basically applies to the logo of this brand. It's as straightforward as it being just the logo of the brand. So if you check Adidas, for example, or Nike, for example, you know that their logo is it Nike that is the tick? I'm not really sure. But then if you check yes, Nike is the one with the tick. So if you check a Nike shoe, or if you buy a Nike shoe, and then it's not a tick that is there, probably a cancel sign, you know that this is not an original Nike product. Do you get? So for brands brands can use this as a way of protecting their own, their own design. So logo is a very good way. Like Puma, for example. So if you see that the logo is not jumping quite everything, is it tiger or that is on it, it's not jumping quite well, you will know, or you will notice that, okay, I don't think this is the right Puma for me. So going on, we have cases. We have Christian Louboutin versus YSL. So the case was about the ownership of red soap. As a lady, if you are familiar with heels, you will know that there are some heels that have particular red heels. And so Christian Louboutin is the first, or will I say, was the first designer to create such type of heel with red sole. Then YSL came into the picture and tried to create same product. So the case was taken to court, and the court emphasized that everybody knows that the red bottom is for Christian Louboutin and not YSL. So the right to retain that particular mark was given to Louboutin. I hope that is clear enough. However, if in a particular place, for example in Nigeria, for instance, let me see. Okay, if I get an instance, I'll come back to us. Please, are we still together?
Yes, we are.
Okay, thank
Yes,
you
we
very
are.
much. Okay, so for instance, every POS stand has, POS, what's it called? A POS logo on it. Then imagine you, Shola POS, that just has a POS logo without Shola in front. Takes another POS shop to court, the person uses a POS logo. The court will not attend to you because they know that every single shop that does POS uses POS. I hope that explains better. So then we go to comedy. The comedy industry is one of the fastest growing industry in the world, particularly in Nigeria, where we have increasing numbers of stand-up comedians and skit makers on the online scene. The comedians are engaged by different companies as brand ambassadors or influencers to boost sales or services for such companies. In the course of creating content, most of these comedians suffer what we refer to as joke theft. It is as straightforward as that, joke theft, or stealing of a person's joke, or joke preferring, or anything you want to call it. But the type of IP protection commonly associated with such creatives is copyright, where these online contents are protected against infringement by other comedians. So we'll be taking a case study, although not Nigerians, but I think it goes well with what we're trying to discuss here. That's Foxworthy versus Custom Tees. In this case, the plaintiff was a comedian known for a series of jokes prefixed with the phrase, "You might be a redneck if," for example, you might be a redneck if you eat too much beans. You might be something like that. But everybody knows that this joke starts with, "You might be a redneck if." Do we get it? So these jokes appeared in a comedy album, a calendar, and on t-shirts. The defendants reproduced the comedian's joke on a t-shirt for sale. The judge found the custom tees replicated on those words and amounted to copyright infringement. What we're saying is that everyone knows that this joke is for Foxworthy. So you picking the joke and using it for your own benefit without the permission of Foxworthy has made you a joke thief. So do we get it now? So the copyright basically protects that from happening. It protects the joke theft from happening. So I think that's straightforward now. So we'll move to broadcast. Broadcast is another aspect of the creative industries that needs protection. Broadcasters' rights are derived from their creative and economic inputs, namely the assembly of programs on the broadcast signals and its delivery to the audience. Not for the content of broadcast, not from the film, but from the act of broadcasting itself. These broadcasters are protected by related rights or neighboring rights. So what protects the broadcasters is called the related rights or neighboring rights. The general purpose of related rights is to protect the people or organizations that add substantial creative, technical, or organizational skills on the process of bringing a work to the public. So basically, what we have just highlighted to everyone this evening or this afternoon is that for every creative work, there should be a protection available to you. So that we are saying that if you have a creative work, then you must be able to find a legal or a lawful protection to your work, irregardless. It doesn't have to be like, the office work. It doesn't have to be the big work, but for every work, for every genuine work of yours, you should be able to, find a protection for those, regardless of whatever it is, whether it is fashion, comedy, and so on. I think we've come to the end of this presentation. Thank you very much.
Thank you very much.
Once again.
I think the presentation was a very beautiful one, and I particularly enjoyed your examples. And I like the fact that you were not just reading it, but you had like an understanding of the subject matter. So well done. Let's hear from Group 1 if they are ready.
Okay, good afternoon, everyone.
Good afternoon.
My name is Ogunsonya Esther, and I'll be presenting the topic Intellectual Property Protection for Creatives. And this will cover literary works, visual arts, and dance. So in order to be able to talk about this, I'll briefly give an introduction, then I'll move to the meaning of intellectual property protection, then to importance of intellectual property protection, then to the protection of literary works, visual arts, and dance creative. Now, moving to the introduction, due to the fact that intellectual property are intangible in nature, meaning that they are not something you can physically hold on to. Due to this reason, most of the creations of people, like when an inventor creates something, most of these creations are open to theft. And theft in this aspect relates to like piracy, misuse, and the likes. So in order for this creatives not to be misused, intellectual property law tends to create certain protection for these creations, for the work of the inventors and the creators. So I will then move on to the meaning of intellectual property protection. Intellectual property protection basically covers the protection of inventors or creators' rights with respect to things they create from their intellect. And as we all know, intellectual property covers creations of the human intellect. They are creations that come from the mind. They're not just something you just come about. Something that you have in mind. So intellectual property protection basically cover this works of creators and inventors, things like literary works and the likes. Under the Copyright Act, the Copyright Act lists certain type of creatives that can be protected by law. And the section that is applicable is section 1, subsection 1A to F of the Copyright Act. And under this section, the type of creative that is protected by copyright includes literary works, just like I've said earlier, literary works, visual arts, cinematography films, dance, broadcasting, and recordings and the likes. So then this takes us to, hello, can you hear me, please?
Yes, we can hear you.
All right, thank you.
Yes, we can.
All right, thank you. So that will basically take us to literary work protection of literary works under intellectual property. Now, sorry, Mira, can you please help me with the slide? Hello, Mira, are you there? Hello, can we all hear me, please?
Yes, we can hear you.
All right, I think, Okay, I can't see it here. All right. I'll just move on to the literary work protection. Sorry. So a literary work generally, the general idea we have about literary work is that it is all about written piece, like novels, like storybooks and the like. But under copyright, literary work is not limited to novels. It includes also computer programs, computer software, databases, articles, emails, conference papers, songs, and the likes. Now, literary works under copyright does cover a lot of things. And for it to be protected by copyright, there are certain things that must be present. The first thing is that it must be the expression of, it must be the original expression of the writer's idea. That means it's not just something that you have in your head. It must be something that you have already put into effect. You have put it out, maybe in writing, or maybe you put it on a computer program, or in song lyrics and the like. So it must be the expression, the original expression of the writer's idea. And secondly, also, for a literary work to be protected under copyright, it must not be like a copied work. It must be your own personal, it must be original, it must not be copied, it must be original. So the owner can make and distribute the work, and the main purpose of copyright protection for literary works is that it enables the prevention of others from creating or selling and using that particular work as it is their own. You know, there are some cases where you get some particular songs that looks somehow similar. They kind of look somehow similar, but where it has been copyrighted, it should be easy for people to show that, okay, this particular work is different from the original one. Now, an example for better understanding can be seen in the case of Newspaper Licensing Agency Limited and others versus Meltwater Holding, BV, and others. In the case, the defendant accessed, okay, thank you, Mira. The defendant accessed the claimant's newspaper website. The claimant is an agency, a newspaper licensing agency. So the defendant accessed the claimant's website and took out certain information from the website. And that information, he distributed it to his own particular subscribers as if it was the one that actually came about the information on his own. So the claimant now sued, and the defendant was trying to raise the defense of that they do not need license to use the information, that they are free to use the information or something like that. So the court held that the defendant and the association were liable for infringement, that since they didn't obtain the necessary license, like the license here talks about like the consent from obtaining consent from the original owner of the information from the website, obtaining consent to use that particular information that they brought from the website. Now, not obtaining that particular consent, infringement on the rights of the claimant, that is the newspaper licensing, infringement for not obtaining together, please.
Please, can we hear her?
Can we all hear me, please?
Yes, we can hear you now.
Yes, we can hear you now.
Yes, we can hear you.
All right, thank you. So, did we all get the literary work part?
Yeah, that relationship. So without that, I wouldn't have 1/6 and 1/6
Hello?
of my finger. And
We
that.
can hear you. Please continue.
All right, so then that takes me to intellectual property protection for visual arts. Visual arts are works which include paintings, drawings, photographs, applied or decorative arts and crafts, sculptural works, and the likes. Now, for a visual arts can also be referred to as artistic work. So here I'll be using more of artistic work. Now, for an artistic work to be protected, it must be a it must be an expression. It must be something you it must be evidence in your mind. So it must be a creative expression of the artistic idea and not just the idea itself. The idea behind this is that you can't copyright something that can't be seen. Like, you know, when you go to court, maybe there's a case in court, and as a lawyer, you're trying to prove something. In order for you to prove it, you have to show evidence, and the evidence may be something in writing or like a document or a video clip, and like you can't just say it in your head. Even if you bring in like the evidence of another person, there's something we call hearsay evidence, and there are some things that have to be proved before hearsay evidence can be admissible. So in this case too, in relation to visual arts, you can't the law can't protect just an idea, the idea you have in your head. The law can't protect it until you have bring that particular idea into something that the law can see, maybe like in the form of painting, your drawings, your sculptural work, and the like. That is when the law can protect it. And in this case, I'm referring to copyright. Now, also, an artwork may be protected under one or more. Hello?
I said you can start rounding up.
All right, thank you. So also, an artwork can be protected under one or more of the various intellectual property rights, and it can be protected under copyright, under trademark, under patents. In the case of Harrio versus Prince, here, a particular photographer published a book of photographs. Now, another photographer now made some paintings, and in that painting that he made, he extracted some paintings from the previous photographer. From the work of the previous photographer, he extracted some paintings and added them to his own new painting. So when the claimant, the original owner of the artwork, when he discovered, he sued, and the defendant claimed to have used the artwork fairly. That means he was trying to claim that he has not infringed on any rights here. And the court held that there was no form of fair use, that the artwork was not fairly used. Since for the work to be fairly used, that means there must be some form of critique in the previous work. And maybe you found the new photographer found some defects in the earlier work, and he tried to bring something new to add to the previous work. then in that case, it would have been said that he had used the earlier work fairly. But in this case, the defendant didn't do that. He just extracted it and used it for his own particular work, and he put it out for exhibition. So the court held that there was no form of fair use in the work, and the defendant was liable. So that will take me to intellectual property protection for dance. A dance is considered a creative work that can be copyrighted if it is a coherent whole and not just individual move. Now, under copyright, dance is covered under choreography. And the section that talks about choreography under copyright law is section 39 of the Copyright Act, which defines choreography as a composition of movement or gestures created to accompany music. That means it is not just a single move, not just one move. It must include different moves before it can be protected under copyright as dance. And okay, an example is this new dance. I don't know if everybody knows or have heard of it. The one-legged dance in Nigeria now. That dance, there's a part of it that you have to tap your leg first. Then the next part you have to bend and shake your shoulder. And it's not just one move. It's encompass different moves. That is when a dance can be protected. If it is just one move, it can be protected by law, according to Section 39 of the Copyright Act. Now, also for it to be protected, it must be original, just like for literary work and visual art. It must be original. It must not be the work of another person. It must not be the dance that another person has like made or something. It must be original. Also, it must be written down, recorded on video, or documented in some manner. Just like I said earlier, you can't copyright an idea you have in your head. It's something you already, that you can showcase, that you can copyright, although it will be the expression of that your idea. So for a dance to be protected by copyright, it must be original, it must be written down, recorded on video or documented, and also it must encompass different moves, not just one move. So also, like other rights protected by copyright, it is not required that dance be registered. Now, what this part is saying is that once you create something, you automatically have rights over that particular thing. So it is not necessary that, it is not compulsory for you to register it before you can exercise your rights over that thing. But however, it is wise that that one should register that particular thing. So just in case of future disputes or something, because once you do not register it, it will be difficult for you as an inventor or creator to prove that you actually created that dance or particular creation, except you have to now go to bringing in a lot of evidence to prove that you have been the dance has been made for a very long time, maybe bringing in people to actually prove it. So it is wise for a creator or an inventor to register that particular creation or invention in order for easy proof of ownership. Now, in the case of Martha Graham, there's a particular dance called the Martha Graham dance, which was produced from a dance center, which is the Martha Graham Dance Center. Now, upon the death of Martha Graham, she tried to transfer she wished for the copyright to be transferred to her hair. But the court held that since this particular dance was invented by the center, that it came from the center, not particularly Martha Graham. So as such, the copyright cannot be transferred to the hair. And in order to explain this further, some scholars, Abitabio and Janet Pisano, stated that if Graham had either copyrighted her dances or signed a written contract, then it would have been easy for her to maintain that particular right, and also she can transfer it, because an intellectual property that can be either transferred and be sold, you can give consent for someone else to use it and the like. But in this case, Martha Graham didn't register that particular copyright, that particular dance under her own name as the inventor of the dance. So that was what happened in the case. So for just like I said earlier, for a dance to be protected under copyright, it must be original. It must be the expression of the inventor's idea. So in conclusion, it is important for creatives to understand the concept of intellectual property protection due to the, this is as a result of the intangible nature of intellectual property as stated earlier. It is very easy for the rights of creatives to be infringed upon. Now, this one is just saying that for every creator, you have to try to like register that particular thing you created, so that your rights will be protected under the law. Therefore, the need for creatives to be enlightened as to why and how they should protect their works. Thank you.
Thank you very much, Esther, for the presentation. Well done. Please, let's hear from group 3.
Oh, good, I did rubbish.
Okay, so good evening.
Good evening.
Good evening.
Thank you. Please go ahead.
Can you hear me?
Yes, we can hear you.
Okay, so I'm taking the topic, the intellectual property protection for creatives, particularly the films, the music, and the software programs. So, the introduction. Undisputably, intellectual property has gained significance in economic development essential for economic growth. So nations across the globe pay attention to this important property as such, and as such, they are intellectual property protections to enable continuous innovations, creativity, artistic works, designs, etc. Intellectual property, known as freedom of minds, has its protection, which includes copyright, patents, trademarks, trade secrets, etc. So creatives, basically films, music, and software are creatives, yes, and as such, there is a need for us to have an intellectual property protection to protect these particular creatives from being stolen or being used on its own, to prevent them from infringing the rights of the creators or authors of these particular creatives. So moving further, we have, why is intellectual property protection relevant for creatives? So firstly, we have to protect the identity of the property. So we know that the property in this question is intellectual work of the creator or author, and the creative works includes, and creative works such as music, films, or some other creatives are easier to be stolen, and as such, there's a need for us to protect these particular creatives. And the protection identifies intellectual property, and this protection identifies the works of this author as their intellectual work. So it makes a distinctive identification on the property of authors, so it won't be stolen easily, and the users or the consumers of this work will know where it comes from or where it originates from. So it will be attributed to them as their work, and they will have an opportunity to exploit their economic rights on their intellectual works. So moving further, to reward the creators for their work. So authors and creators develop their work out of their ingenuity. They create work out of their minds. That's why intellectual property is defined as the creation of minds, and as such, so intellectual property laws or protection rewards them for this. So and the intellectual property laws protects the interest of the creators by giving them proprietary rights over their creations, and invariably granting the exclusive proprietary rights to the creative, to the author or creators, creates an incentive for creators to develop, produce, use, and distribute new and genuine goods and services for commercial purposes. So therefore, they can have rewards from the works, the intellectual works they produce, or the intellectual works they developed. So moving further to strengthen competition, authors and creators do not want competition and do not want their competitors to use their ideas to develop newer products to beat their products in the market. So they use intellectual property to protect their creatives, to make it theirs, and then the competitors in the market also find a way to bring out a new idea to ensure that their product also sells in the market. And this ensures competitions in the market, and different authors and creators will have an opportunity to sell their goods, use their goods, license their goods to different persons. And this eventually will have a great impact in the economy of the country, as there'll be increase in sales or increase in demands of different products per se. And having the intellectual property laws protect the ideas and where the ideas and competitors or authors of different intellectual work won't be able to steal the idea or the underlying idea of a work to help them or to fit the needs of the people using or consuming that particular intellectual work. I hope you guys are with me. Hello?
Yes, we are with you. We are with you.
Okay. So I'll proceed to the last one, fair return of investments. So, when developing or when creating a particular intellectual work, a creator puts a lot of money, a lot of expended time, energy to create or to develop their intellectual works. And to make it success, they have to do all these things that they are needed for a successful intellectual work. So the process is expensive and it's really time consuming, but intellectual property laws reward the creators in the long run. So the expectation of the economic rights gives the creators an avenue to have a fair return or get their financial returns or investment, financial returns or financial reward from their investment and time. So this basically means that no matter how much money they invested in to create a particular work, or let's say, for example, film, to create a particular movie takes time and it takes a lot of energy, money, and whatsoever. So if the intellectual property can have an avenue to protect this particular film, no matter what, if this film is properly protected, then they will have a fair return of their investment, their money, the energy. It won't be a waste, and they will be able to get a lot from what they produce, and even more than what they added or they imputed to that particular work. So progressing further to the first creative we're talking about is film. So film, as we all know, can also be regarded as movie, and the International Monetary Fund described Nollywood, which is the Nigerian film industry, as the second biggest employer in the world. And by this, we can see that the Nigerian movie industry is one of the essential industrial sectors in Nigeria that gives a lot of economic value to the country, and it's really affects or it's really have great impact in the GDP of the country. And as is seen here, by 2016, an estimate of 239 billion of Nigerian GDP was attributed to the film industry. So this shows the importance of the film industry. And if the films of individuals, of creators, are actually pirated or they are stolen from them, then this particular the country won't be able to have enough income or generate enough income from the film industry. And the intellectual property available for film industry protects the film, particularly from the scripts, from when writing the script, from the cast whatsoever to the screen. So it protects each and every step of the filmmaker's journey. So progressing further to the intellectual property protection available for films. First of all, we have the copyright, and for a work to be eligible for copyright, as it is in Section 1 of the Copyright Act. So the Section 1 of the Copyright Act has outlined the eligibility for copyright, and we can see that cinematography is one of those that is eligible for copyright act for copyright in Nigeria, for copyright protection in Nigeria. So we can see that copyright protection is one available protection for films in Nigeria. And the precondition before it can be protected is that it must be original. That means it must be a new idea from the creator, and also the fixations must be expressed in a fixed manner. So there'll be a fixed expression, and also there'll be a qualifying factors. So we just move further to the protection of the films by the copyright protection. copyright is regarded as the lead chain of film-making enterprises. The basic protection that is available for film is the copyright, and among other things, it protects the creators or owners of the rights by preventing others from using their works without their permission. So, be it the script, be it the movie itself at the cinema, without the permission or the consent of the creator or owner of the film, others can't make use of that particular work, if not to be considered as a copyright infringement. And now, continuing further and progressing further, filmmakers can copyright their scripts, their character, their screenplays, the stage direction, the stage designs, etc. So they can use specific copyright protection for their words in the script, for their performances, which deviates or which adds to the script, and which also has the inclusion of human embodiment. So this basically means that most times when acting on stage, it's not really what is in the script that is said on stage. So the owners or the actors or actress in that particular movie adds or moves a little bit from what is to suit those watching that particular movie. So not only what is written in the script will be protected, the movements, their human embodiments, what they added or what they moved from the script will also be protected by the copyright. So moving further to patents rather, it protects the way the tools are used and designed for filmmaking. So as used, patents, the utility and design patents are mostly used for filmmaking. So utility patents protects the way an invention is used, while a design patent protects the way an invention looks. So firstly, filmmaker uses tools such as tripods, such as camera, and so on to create their films. So these objects will also be patented. Utilizing or making use of these tools will lead, it will have an improvement to what makes the film better, and also it will have an added functionality to the item used in that particular film. So the filmmaker uses the patent law to protect the innovative ways they use these tools. So secondly, filmmakers make use of software tools also in their films, such as the 3D, the animations. So this aspect is also protected and patented by the design patents. So not only what is acted on stage are protected by the intellectual property protection, but also the tools used in making the film a success will also be patented. So moving further to the trademark, filmmakers can make use of trademarks to build their brands, and trademark signifies like a word or a logo that shows people where a product comes from or who it belongs to. So producers of film, the manager of film, okay, this production, that production has a specific logo that is protected by trademark to show that yes, this particular film was protected by a particular production company. And as such, so movie studios use trademark to create a distinctive identity and to stand out in the crowded marketplace. So movie titles such as well as the key characters in the film and other film elements are protected by trademark. So registering these film elements open doors to lucrative licensing and merchandising agreements that can help that can defer the cost of production and film promotion. So the money they get from this protection will help them like have enough incentive from the cost of production or what they've imputed to the success of that particular movie. So are you guys still with me?
Yes.
Okay, so moving further to the case. Okay, so the case of Tobore and Mo Abudu. This is one of the most controversial issue about filmmaking in Nigeria. And in this case, Tobore, the claimant, was a journalist and she had an investigative research on human trafficking in Nigeria. And as such, she also witnessed or she also suffered from the human trafficking. So she wrote an article about human trafficking, expressing or telling the public about the things she has suffered from human traffickers. And at that moment, she's an employee of the Premium Times. So later on, the defendant is a producing company, and they wanted to make a film regarding human trafficking. So they came across the article or the write-up of Tobore, and which actually have a complete sense of human trafficking to show the bad and the effect of human trafficking on the victims themselves. So they used Tobore's article for their movie, and Tobore sued for copyright infringement. That number one, they never asked for permission or consent for using that particular write up as a script or the plot of that particular movie. But the defendant has also claimed that they had an agreement with the Premium Times, who Toberi works with, and so that was a controversial issue. And actually, it was seen as that Toberi's copyright was infringed in that that Premium Times never asked for her permission, but she was the owner of the work, and therefore, so they need a commission from Toberi before a write-up can be used for film. So that's one of the controversial issues of filmmaking in Nigeria regarding the infringement of intellectual property rights. So can I proceed?
You can start rounding up.
Okay, no problem. So moving further to the music industry. So the copyright protection for music industry is number one, the eligibility. So section 1B and E of the Copyright Act shows or makes sound recording and music work they make it eligible for copyright protection. So section 1B of the copyright makes musical works eligible, and section 1E makes sound recording eligible. So the precondition is the same originality, the fixation, and the qualifying factors. So a case for this precondition is the Dendali and Tiwa Savage case. So this case basically based on the originality of the particular work. These two parties to this case are artists, they're Nigerian artists. So Dendali sued Tiwa Savage for stealing a particular word or particular sentences from his own music to Tiwa Savage's music. And so please permit me to speak Yoruba. And it's the particular sentences in question is a Yoruba adage, the Ododun Arogo and Ododun Lararosa. So the controversial or legal issue, or legal question that arose from this particular case was that the word that the claimant accused the defendant of stealing is it an original work? Like, okay, can a Yoruba adage qualify to be an original idea of a creator? So it was gotten that the Yoruba adage is popular and is not original. So therefore, anybody can use that particular adage for anything they want to use it for. Therefore, so it was not liable for any copyright infringement. So the protection available for music industry. Okay, so the sound recording copyright and the musical work copyright. The sound recording copyright is associated with a specific recording. Once an artist produced a recording, they assume ownership of that particular recording or assigns ownership to the record label that represents them. So this will be the singing of the song itself. So the copyright protection also protects the sound recording of a particular music. The other one which is protected is the musical work, and this deals with the musical composition of that particular song, which is made by the songwriter of that song. So the ownership of this protection is given to the music publisher, and most times songwriter earn a living by selling this particular lyrics of a song to a music company or whatsoever. So that's the way where copyright protects the intellectual property rights of creators and authors. So one of the goals of copyright in music industry is to create a condition for the creators to be able to earn a living from their talent by getting a financial return on time and the energy they put into producing a work or being recognized as its authors. And also this copyright also confers the economic right, which includes the right to reproduce the work, which is the music, the right to transfer the work, the right to perform or display the work, and the right to make new creatives based on the original underlying work. So the copyright also confers economic rights to the author or creator of music, and also it also confers moral rights by allowing the author to claim authorship in the work and object to any modification of it that may be prejudicial to their image or their integrity. And this was entrenched in section 12 of the Copyright Act, which is popularly regarded as the moral right. So moving further to the trademark protection that is available for music. So the trademark protects the music brand generally, which consists of the logo or the words or anything relating to the brand that produce that particular music. So it's used in the music industry to protect the brand's name, logo, and whatsoever. So trademark protects the things that helps the fans or consumers identify the source of that particular music. So the musician and band members or those music companies can sell merchandise, and trademark is an essential way to ensure that that other parties are held accountable if they try to profit through the sale of counterfeit products. So moving further to the case there is Emelica and Gambino. So in this case, a line, yes, this case is similar to that of the Dali and Tiwa Savage, but the claimant was the defendant actually infringed the right of the claimant. So in this case, a line was stolen by Gambino in his own music, and Emelica sued Gambino for that particular infringement, and the court held that Gambino really infringed on Emelica's right, and Emelica was compensated for that. So moving further to the intellectual property protection available for software programmers. Okay, so we know software are programs or other operating information used by computer, and as such, there are instances whereby this software are pirated, that software piracies, and it's even rampant in Nigeria because everybody wants to get from the innovations of others, and the copyright and the IP protection available for the software programmers are copyright protection. So number one is copyright protection, and we have the eligibility. So the section 1A of the Copyright Act provides for literary device and literary works which is eligible for copyright, and there's no place in section 1 that actually states that software or computer programs are eligible for copyright. But actually in section 51 of the same Copyright Act, the software programs or computer programs were regarded as literary work, and such they are eligible for copyright protection. And the protection of this is that it protects the unique expression of the software programmers as described in the source code and object codes. So a software programmer is guaranteed automatic copyright protection in his source and object codes, the codes used to develop that particular software. And if his original work, and if he actually expressed that particular software in a fixed and definite medium of expression, which is the preconditions. So software protects the object codes and the source codes for development of that particular software. So move further to the patent. So patent protects the method and processes used in developing the software. So patent protects the invention, including the method and processes used in developing the software, and software is eligible for patent protection if it involves an inventive step that is not obvious to people knowledgeable in that field and is capable of industrial application. So there's a particular thing that are also noted by patents that's innovation in regards to software protection. It's that if a patent can protect a software, it must be a new idea that is made. It must not be made from the underlying idea of another person or a development of another person's software. If not, patents won't be able to protect that particular software program. And we can see that patents protects the invention and also copyright protects the invention. But the thin line between copyright protection and the patent protection is that patent protection protects the whole of the software itself, but copyright protection does not protect the whole. It only protects the expression of that software, which is the source and the object codes. So progressing further to the trademark, protects the exclusive rights of software's brand name, the logos, slogan. For example, we have software programs like Microsoft Word. Microsoft Word has a particular unique logo which they use, the red, blue, yellow designs and whatsoever. So this particular logo is protected by trademark, and trademark gives the proprietor the exclusive rights to use the mark in connection with their software and enable users to distinguish the inventor's software from other software available in the market. So the example I used before, like the Microsoft, there's no how you see Microsoft software that you would not be able to identify that this is for Microsoft due to the unique logo and the unique protection that is attached to the Microsoft or Microsoft company. And it also promotes the brand and may prevent third parties from marketing their software under a confusing similar name. So moving further to the trade secret. So trade secret basically protect the confidential information, the codes, and the processes of which has commercial value and which accords the owner a competitive advantage over the competitors in the market. So there's some particular process which the software programmers use to develop that particular software, which must be protected by trade secrets. So trade secret protects the confidential information, the processes which the software was developed, and the codes. So the case for this is the Microsoft Corporation and Yogesh pop parts and another. So we know Microsoft is a popular software company who produce different software applications. And so in this case, the defendant, who also has a company, illegally sold a pirated Microsoft software in the machine, which was assembled by the defendant himself. So the EI court, since it's an Indian case, the EI court held in favor of Microsoft Corporation and granted them compensation in that the defendant has infringed upon their software programmer. So this is a software program. So this is how the intellectual property protection helps to protect the software application and software programs of software programmers. So moving further, conclusively, the understanding of IP in the creative industry will help the creatives to protect their intellectual property at all costs. If there's an awareness program about how creators or authors of works will be able to protect their work, their intellectual work, then the intellectual property ensures that the authors and the inventors maintain their rights to their authorship and earn a living from their work. Thank you very much.
Thank you so much for that presentation. Well done. It was presented well. Thank you. So let's hear from group 4. Please go ahead with the presentation.
Good day, ma'am. Sorry, it was the network. My name is Omladi Madina. I'm going to be presenting on behalf of okay, so the topic I'm presenting is the importance of contract and contract review for creative. So my outline is definition of contract. So can everyone hear me?
Yes, we can hear you. Please, you can rotate
Yes,
your
we can
screen
hear
as
you.
possible.
Okay. Contract is the Nigerian creative industry, necessary clauses in a creative contract, importance of contracts to the creative industry. So first is definition of contract. A contract is an agreement creating and defining obligations between two or more persons by which rights are acquired by one or more to act of forbearance on the part of the others. So then the contracts in the Nigerian creative industry. The contract in the Nigerian creative industry are legally binding agreements between the parties, which are used to establish intellectual property rights, ensure the protection of such rights, confer rights to other parties so as to prevent disputes which may occur in future. Necessary clauses. So an IP clause is a contractual provision governing the ownership, title, rights associated with IP, such as creative development, designs, etc. So there are necessary clauses that must be included in the contract, depending on the kind of contract, what the contract is based on. So the first one is non-disclosure agreement. Creative contracts should provide confidentiality, and the non-disclosure agreements are popularly known as NDA clauses. So NDA clauses, creative contracts should provide confidentiality and NDA clauses in order to protect trade secrets and confidential information of the employer, which the employee may have access to or use in the course of their employment. While this clause is important, is that trade secret of significant value and loses its value and protection as soon as it is known to the public, and is also used to maintain the competitive edge. For example, if you see a Deola Sagwe clothes or Fisayo Olunge's clothes, you'd always know and you always recognize it because of their particular look. So if Deola Sagwe or Fisayo Olunge employs someone to work for her, the person may have to sign an NDA so as not to carry a trade secret. That's the trade secret, because once a trade secret is already leaked, then that IP right becomes useless. So the person has to sign an NDA so as not to leak the trade secrets, and if the person breaches such, may face some penalties. So the second necessary clause is the agreement transferring IP rights. So agreements to transfer IP rights can include assignments and license. So in an IP assignment, there can be a clause to specifically transfer the title from the assignor to the assignee. The assignor is the owner, the assignee is the person that the right is being transferred to. So in this assignment, they are assigning the title to another person. And it's the clause should also indicate the clause should also indicate the particular right the assigner is assigning to in a work. And it also states that the rights being assigned and the limitations in which the assignee may use the work. But in licensing, there is no transfer of title. You just like license maybe a particular right to another person. Then, and the clause should also state the right that is being assigned, whether it is copyright, whether it is trademark or any. Then the joint development agreement. So joint development agreement is an important, it is actually a type of agreement that may be separated from the contract. But if it is included in the contract, it's an important clause, and this is specific to people that two people who are coming together to form a company. So, for example, I want to open a restaurant. I know the secrets. I know a spice to make the chicken like the best. Then another person knows a spice to make the jollof rice the best. We have to enter an agreement because in case if we are separated or something. So a joint development agreement is used when both parties bring valuable proprietary know-how and IP to the table, and any of the pre-existing IP is owned by the party that developed it. So let's say I've started the restaurant earlier and I have like a particular IP rights before the other person comes to join me, I'm going to be the one to own the right. And the agreement can also expressly provide that the ownership of each party's respective IP be used during the project remains vested with its original owner, and further that any use by the other parties permitted solely for activities necessary to carry out the joint development work. So basically, if the IP rights in this joint development agreement, if we are using it, we should use it solely for the business and not for any other thing. So they can enter into an agreement that, okay, you may know the secrets to my own spice and everything. That does not mean you should go and open a restaurant behind my back. If such happens, what will happen? Those are the kind of things that we stated in this clause agreement. The parties can also include that the parties will equally own any jointly created inventions resulting from the joint development activities. So this clause basically includes consent from the parties on how to exploit their jointly developed IP. Then obligation clause is the clause that states the obligation each party has towards each other. Like normally in the contract, you have obligations and rights towards each other. So the obligation clause is just a normal contractual term. It states the obligations that each party has towards the other, and they refer to duties contained in a contract that each contracting party agrees to when they sign, and they are responsible for carrying out. So for example, as a music producer, and I sign a musician I sign a musician. If he let's say the agreements will be like, you produce 5 songs in a year, and this is the percentage of money I'll give to you from those 5 songs. So like that kind of thing. They must both fulfill it, and if they don't fulfill their obligations, it may lead to a breach of the term. Then indemnification. So an indemnity is an obligation given by one party to a contract to compensate the other party for some defined loss. So the purpose of indemnification is to appropriately allocate risk between the contracting parties. In IP indemnification clause, the risk is commonly associated with patent infringement, trademark infringement, or any other IP related right. So it obligates one party to compensate the other party for loss or damages covered by indemnity clauses. Then we have the documentation and record of intellectual property, additional charges clause. I'm really going to that because of the time. Then we have the liability clause. It's important to know that liability clause and indemnification are similar. If there is a breach or if something happens, the compensation that the other party received due to the failure of the obligation of the other party to perform its obligation. Then we have a breach and cancellation clause. So if a party has committed a breach of a term or a condition by failing to perform its obligations, then the clause then stipulates upon agreement of the parties, the penalty, maybe termination of the contract, or if there's like a remedy, a financial remedy that may be paid. to the aggrieved party. So that's the breach and cancellation clause. Then we have the governing law jurisdiction. Sorry, breach and cancellation, changes, cancellation and termination, they all fall under the same clause. What if to terminate processes to terminate a contract if there is a breach of a term? If a termination will occur, if there's a breach of a term, they all fall together. Then governing law jurisdiction. So the governing law jurisdiction clause expresses the parties' will for the system of law applicable to the agreement and its effects. So it means that the law of a particular place will be the one to govern. I know that IP laws are territorial. So if the agreement is being carried out in Nigeria, it is going to be Nigerian law. But if it wants to extend outside Nigeria, there are other the kind of IP rights laws that they are going to be used for that agreement would need to be told to them. So that's IP law and jurisdiction. Then importance of contracts in the creative industry. So first is contracts serve as a record of rights, responsibilities, and obligations. It's important to have contracts in any agreement, especially the creative industry, to reduce we hear different problems of a musician not being paid by the producer, the producer and all, or the producer not properly remunerated, all those kind of things. So it serves, so if there are like obligations already set out in the contract, they can easily refer back to them. So if you want to sue someone who has breached your rights as a creative, it's easy to go back. And if you are the creative owner and the person you employed is trying to infringe on your own rights, you can always refer to the contract. Then the second one is states and describes the duties each party owe towards one another. Then contract in the creative industry stipulates modes and process of payment, the exact money to be paid, how frequently it should be paid, the terms associated with it, and or the particular percentage to be paid. It states the exact amount of money to be paid. Then contract in the creative industry ensures that your intellectual property rights are not infringed on. So the terms of the contract serve as a legal basis to sue if the creative's rights are infringed on or taken advantage of. So I'm going to use the case of KSA, King Sunny Ade, and African Songs Limited and King Sunny Ade. So in this case, King Sunny Ade was signed to African Songs Limited, and it was to be with them for 5 years. But he noticed that they were infringing on his copyright, and in the contract stated out, he had the ownership of the masters to his songs. Then the African Songs Limited had the ownership to the copyright. So he wanted to take over the masters of the songs as specified by the courts, because they've gone to the court for the first time when he wanted to opt out, but they weren't allowing him that. He has to satisfy some agreements. Then they didn't, and the courts mandated the African Songs Limited to give him the master recordings of the song, but he refused. So on an appeal, he was able to get a 500 million naira compensation for their refusal to go by the injunction of the court. Then contract also acts as a legal document. I want to go back to that to reference in the occurrence of dispute. I'm going to, there's a case of Michael Jackson where the music industry it was assigned to, he didn't know that there was a clause that said that it must be there for 5 years. And then they will have full copyright ownership to his songs. But he didn't give a lawyer to review anything, and he went to court, and that was when the clause was brought out for him. So it was sort of hidden, but because of his lack of legal knowledge, he didn't know. So it was bound then to the end of 5 years before he could actually opt out. Then we also have the case of Brimo versus Chocolate City. It's still an ongoing case. He's trying to leave Brimo is trying to leave Chocolate City, but because infringement of copyrights and all, but he hasn't fulfilled his duties and obligations towards them. So it's still an ongoing battle there. Then there is also a current case. That one is not yet in court. I think Ilbliss, it was on social media. He dragged his producer that he hasn't been paying him. And when he said that when they wanted to sign the contract, the producer insisted that there is no need for any legal appearance or legal view, that they don't need any lawyer to review their contract and all. And since then, the producer has not been giving him any money or very little money from them. So he said he's going to sue him to court. But unfortunately, most of these intellectual property infringement cases for music especially doesn't really end up in court. They either settle it out, or because of lack of proper review of the contract, the musician is usually at loss. So contracts also outline methods disputes can be resolved and the termination process of the contract if such situation arises. So
thank you, Modina. Are you done? Hello, Modina.
Sorry. So if an issue occurs already, that's why it is important to have the clauses I earlier stated, so they can easily be referred to. And this is a warning or a note to the creatives that most of the creatives, they feel they don't need any intellectual property protection rights. They feel they don't need to protect their intellectual property rights, and they just do things out of free will, sign any document as long as it looks like it's bringing them money. And most of these the people that employ them, or the agencies they are signed under, actually know that they lack this legal mind or legal view to review all these documents, and then they end up being in trouble, losing their copyrights, losing everything, losing their trademarks to them and all. So that's it. Thank you for listening.
Thank you very much, Modina, for that presentation and for the examples that you gave. I would like to thank all the groups, Group 1, Group 2, Group 3, and Group 4. Well done for coming together to research, to put the presentation together, and also for presenting. I would like to encourage everyone that no one should feel bad about their presentations. Congratulate yourselves, and please, on your private groups, try to congratulate and encourage everyone that's presented today, because I think you did an amazing work. Well done. So we'll be going to our mentors to hear from them. It's been a long day, but it's important that we hear from them because they'll be talking about the practical aspects of everything that has been presented today. So without taking much of your time, we'll be calling on Bernice to make the first comments on the presentations based on her experience. Hi, Bernice.
Hello, Juliana. Can you hear me? Wow.
Yes, yes.
Hello, Juliana, can you hear me?
Yes.
Oh, okay. So everybody did very well today. It was very enlightening listening to everybody, especially Group 3. I have to say it. Like, it was almost like they did a lot of research in their work. And when he was presenting, it was almost everything that I wanted to comment on. He was really saying them, and it's commendable to see that people come together to do such great work. So I would like to comment on the area of IP and the fashion industry, because I think that's where I'm very interested in. So basically, when she was presenting, she didn't mention that patents apply to the fashion industry. And I know that when it comes to the fashion industry per se, a lot of people tend to think that patent does not apply. If you say that patent doesn't apply to fashion design, I get it. But when you say that patent does not exactly apply to the fashion industry, it is not entirely correct, or you don't mention it at all. Because I remember when Group 3 was talking about his IP that applied, he mentioned that sometimes you have to acknowledge the tools that are used in the operations of the industry. So sometimes we just try to identify the idea and the IP. We don't look at the operations of the industry. So for example, people like to think that when it comes to the fashion industry, it's just the making of clothes that should be that is protected. So it's nothing so elaborate, but the fashion industry is way more than just protecting clothes. It is more, there's the fashion business that is also entitled to intellectual property protection. But I will tell you how patent applies to the fashion industry. When it comes to wearable technology, for instance, or wearable fashion rather, you will see that patent is a big part of that particular aspect of the fashion industry. For instance, when you have Apple Watch is a wearable technology that is a wearable fashion rather, but then it is technology, it's a gadget that you can use to track your activities and everything else. But the underlying factor of that particular product is a fashion accessory, basically. So that applies to the fashion industry. In that regard, you can say that patent applies to the fashion industry. I also know of people who come up with a lot of technology product that applies to the fashion industry. For instance, there was Swarovski and Misfits. They came up with a fashion ring that actually tracks your heartbeat, that tracks your body temperature, that tracks your activity, basically. That's a fashion accessory, but then it is a technology. So you can't really say that, and that can be protected through patent. There was also the case where somebody invented, I can't remember the person's name, but the person invented a pants where if you gas, it absorbs everything. So you can go about doing your business and nobody would know. It was patented. That's a tight that we basically wear, but then it had like an underlying technology behind it. So fashion, so patents can apply to the fashion industry and would apply to the fashion industry, because where we are going is like the fashion industry is merging with technology, where they talk about metaverse, NFTs and the likes. Although we will not go deeply into that, we are looking at what is obtainable now. You will see that technology applies to the fashion industry in a lot of respects. So patents would apply in that regard. So I know that it always stems from the fact that a lot of people think that the fashion industry is only fashion design, but it is way more than that. Then another thing I would like to comment on is the contracts in the creative industry. I think they left out employment contract, because the employment issues in the creative industry is a lot. Most of them, they do not have, like, if they're not full-time employees, they are part-time. So if you mention contracts in the creative industry, you should be mentioning employment contract or independent contract or service contract. Maybe they would have done a better job identifying who the creatives in the creative industries are. Usually people limit it to only music and the likes, but if they had identified all of the creatives, we have people who go for reality TV shows. Those are like creative, those are like, that's part of the creative industry. We have photography, we have different areas. So there are a lot of contracts that apply, but I think that one of the major contracts that you cannot neglect when you talk about the creative industry is the employment contract, independent contract, or service contract. Those contracts contain a lot of cogent clauses that would guide the relationship between these creators and the bodies that they work with. So in all, it was a very good presentation, and yes.
Bernice, thank you so much for that contribution, and we're excited to announce that Bernice was a mentee in the first mentorship program that we had, and
yes,
she now runs her firm and she's making us proud. We're so proud of you, Bernice. Thank you so much.
Thank you so much, ma'am.
Thank you. Okay, so we'll be hearing from Zerona. Hi, Zerona.
Hello. Sorry, recovering from a bit of a cough. First of all, let me echo Bernice's comments.
Sorry, we can't hear you, Zerona. I think your network.
Fantastic. I was very, very impressed by
Hi, Zarina. Sorry, I think there's a network issue, so we're not hearing you properly.
Hello, sorry, I got thrown out of the meeting. Actually, let me turn on my video so I'm not rude. Hi, hello.
Yes, thank you.
Hi, sorry, I had to swap networks because Nigeria. But yes, what I was saying, I don't know if you heard me before. I was very impressed by all the presentations. Can you hear me now? Okay, good. So I was very impressed by all the presentations, not just the content of the presentations, but the actual visual work that you all created. I thought it was very apt given the subject matter that we are discussing today. I think it was Jeremiah Michael. Was that the person who was speaking? I think she kept saying, and that's straightforward. You know, when she was referring to something, and you know, one thing I noticed was when she said public domain, and then she said yes, and that's straightforward. So my first thought was, but it's not though. Please explain it. But then she went on to explain it. So for me, that just had me chuckling a bit. I have to say that I think it was group 2, because group 2 went before group 1, right? That was very interesting. The issue of public domain with regards to with regards to copyright infringement in particular, something that, you know, I think that a lot of people tend to overlook. Perhaps public domain is wonderful. You know, as I'm assuming that those of us in the room know, and you know for sure now, given what we've heard, is that after a certain amount of time, after the original author of the work has passed on, then the work now belongs to the public domain and anyone can use it, right? Where it is, and I thought that it's important to clear up this issue of fair use, right? Is everyone following along with me?
Yes, we can hear you.
I'm not sure if my network is acting up again. Okay, all right. So I just wanted to throw my hello again. Am I back in?
Yes, we can hear you. Yes.
Okay, I'm so sorry about this. So I just wanted to touch on something that you all mentioned actually, but that's you know, fair use. And I think it's particularly important given sampling in the, you know, the music industry. So, you know, first and foremost, get the permission where you can, because when it comes to sampling, there are kind of the two different copyrights attached to that. You know, there's the copyright in the sound recording. There's also the copyright in the underlying composition. Where fair use comes in is that a lot of people will say that, oh, I'm using it for, you know, whether it's education or, you know, or you have de minimis, which is, you know, what I'm only using a tiny amount. I'm about to give up on this internet. Anyway, just to cut it short before I get cut off again, we have to advise our clients to always be very cautious when it comes to, you know, using work that has not been properly cleared, and to make sure that any and all agreements that are associated with that have the use, the expected use, delineated and unclear. And
Sorry, so the network is dragging now. I'm not.
Properly,
The network is dragging.
Exactly. Okay.
Maybe
Can
if
you
you
hear
put
me
up
at
the
all?
video, it might be better. Yes, yes, I can hear you now. Yes, I can hear you now. Please let me know if we can hear her properly or if it's just on my end.
I can't, ma.
Okay, okay. Okay, so while we're waiting for Zerona to be back, let's hear from Mr. Folarin. Hello, Mr. Folarin.
Hi, Juliana. Hello. Good evening.
Good evening, sir.
Yes, good evening, Nigeria, Central Abi, GMC.
Good evening.
Yes, to those from a different time zone. Can you help me kill this one? So I'm about to turn on my video, and I'm just trying to make sure. I was in court today, and in Abuja, it's very strange to be in court on a Friday, but well, I guess it comes with the territory. So nice to be here. I had the opportunity of looking at the presentations. I did catch bits and pieces of the other presentations. I should say very well done to everyone, first of all, and particularly well done, Juliana, for being consistent and for keeping this program, running. I can tell you that. Excuse me, I'm not wearing my glasses, so you forgive me. But it's not an easy thing to do. Consistency is actually one of the key traits of leadership, and you've shown considerable. You've shown that you have what it takes to be a leader in the IP space. So well done. And to the mentees, please.
Thank you, sir.
Take advantage of this opportunity. These are fantastic people. I was listening to Bernice, talking so passionately about fashion law, and I said I was trying to take notes, in between, following what she was saying, and that's fantastic stuff. Fantastic stuff. So I would say well done to everyone. The presentations were pretty well researched. I caught the end and then bits and pieces of them here and there. I think my thoughts on intellectual property law for creatives, or intellectual property for creatives, can be summed up from a Nigerian perspective. I think can be summed up in two words. I think I would say ignorance and selfishness. And selfishness, that's at the moment anyway. Selfishness because our creatives tend to think only in terms of themselves, which is, Benny said, wow. From the little experience that I have, you find that many people in the creative space in Nigeria, many, not all, but many, are not, they know that what they have is valuable. They know that their intellectual property is valuable, but a lot of them are not ready to engage professionals. And I'm not just talking about, I'm not speaking as just a lawyer, but if we're talking about accountants, and other professionals within the industry. The other day, I was with someone, a photographer, and we're trying to put together like a hybrid, type of event for creatives. And it was so difficult getting them to collaborate. And I think that's where the selfishness comes to play. That's where we see it play out. So I'm not saying it's not necessarily, it's not a good thing because it doesn't help them grow. It doesn't foster much growth, and if you look at the creative industry or the entertainment industry generally, and that I would guess that includes sports. Bernice was saying, talking about the mentees creating parameters or defining, what areas actually constitute the creative space or the entertainment space. But if you were to look at all the various categories, I think one thing you will find is that you find a lot of people working on their own in silos. So that's one major challenge. It's very difficult helping creatives if on the first hand they can't even organize themselves to into some kind of pressure group. Someone did that very recently, maybe about 10 years ago or so, for the music industry. And I think to a large extent, that's one of the reasons why music has, is still evolving at the pace at which it is. Nollywood drove development I think in the 60s and the 70s, the music industry drove development in entertainment in Nigeria. But after the indigenization and nationalization decrees of the late 1970s, which saw the exit of some of the big record companies, some of these big entertainment companies from Nigeria, and other companies in other sectors, Nollywood kind of took the center stage. And so from the 80s to the 90s, Living in Bondage, and all those other movies, Nollywood pretty much defined the growth or the trajectory of the entertainment space in Nigeria. But then, and I think it was the Plantation Boys. I think it was African Queen. African Queen was the game changer because that song, I think, resonated across the world, and it was picked, by movies, by shows, from a lot of people wanted to use that word. And, that kind of put Nigeria on the map of Nigeria's music industry. But the point is that the ability to come together to organize and then to speak with one voice goes a very long way. That is how the movie industry or the entertainment industry in the US and in other places, have pushed legislation or have made, significant progress in terms of pushing their agenda. So I would say selfishness on the one hand, and then ignorance on the other. The ignorance is born out of the fact that creatives know that what they have is valuable, but a lot of us don't understand the value of what we have. So we could think of value in the abstract as, something that has, is valuable, but value is not an abstract concept. Value actually is concrete, and it's concrete because value is linked to some kind of, if you are to have, you can't have general value. Value has to be relative to something. And most times we define value in relation to its economic value. Of course, you could have cultural, social, and other types of value, but now we're speaking about economic value. So I think the other problem is that our creatives don't know how to value the work that they have, and they don't understand that a plot of land, lying fallow may be worth X amount, but until you build a wall, you take possession as lawyers, you take your possession, dig a foundation and put a building on it, the value does not appreciate, in real terms. So in the same way, a work in itself a song may be nice. In fact, a song may even not be not so, you might have a song that's for music now, that may not be nice or may not sound nice, but with the right kind of promotion, that song can be driven, it can be sold to the public, and then people will hear it. Or I'll give another example. You can have a painting or a work of art that does not appeal to people during the lifetime of the artist. And there are so many examples. Van Gogh, for example, was somebody who was not really appreciated during his lifetime until he died. And there are many other, visual artists who fall into that category. Not everyone is Pablo Picasso, but you can have a piece of work that may not be valued or recognized during the lifetime of the author. And then, subsequently, Jimi Hendrix, for example, Michael Jackson, their works have been valued. Even the Beatles, their catalogs, their IP, their works have been valued, have increased in value after their deaths or after they exited the stage. But then the question is, what is the economic value? Can you put a number to it? So you see a situation where an artist walks into the office, into the firm, for example, and says, "Oh, I want to sue someone. Someone stole my work," and you want to sue the person for 100 million naira, for example. Now the song has not even gone anywhere. The song has not been promoted, but the artist expects that by intrinsic psychology or by some intrinsic magic, that IP is worth X amount. Without considering that something has to go into it to build the value or create additional value, or build the economic value, if you will. So I think, and that has to do with, it's closely linked to recognizing that when you're talking about the economic value of IP, you have to link it to a number that is based in reality, and you have to think of it like a business. So I think to a large extent, I would speak to, in summary or in rounding up, I would say the good thing about these two problems is that they are not problems that persist forever, and that is one of the reasons why programs like this, mentorship programs like this are very important, because the more we talk about this, the more ideas, come into cyberspace, and the more these ideas are put out there, the easier it is to reach out to these people, because to a very large extent, many of them, many creators, and I think this speaks to our culture. Many creators actually love to create, and our culture needs, society needs creators in the same way that creators need society. So it's important that these conversations go out there, and I would say once again, fantastic work, you guys. In terms of intellectual property rights, I would love to see a situation where we would look at ways in which, our copyright system, for example, because we're talking about creatives, I think copyright will be like the primary. Of course, we have trademarks, and I was joking with an OAP on World IP Day. I told him, what if somebody registered your name as a trademark in class 41, for example? And one day while you were on air, called you and said, stop using that name. There are no more Iganacho prints on there. What will you do? And that's because you don't have trademark trolls in Nigeria. But, so I'm not saying all the other trademark intellectual property rights are important. Benny's talked about the importance of patent rights in fashion. You'll be surprised how many patent rights Disney owns today. As Disney, the multimedia company, they own so many patents, But let's say copyright, for example, we should start thinking about how to strike, what policies should we, or what conversations should we have to strike a balance between the realities of the digital economy and our copyright system, how we can use it to promote the work of Nigerian creators. And I'll explain why. In the United States currently, there's a huge push by the Motion Pictures Association, to going against streaming companies and streaming, and I'm referring to companies that like hijack streams, broadcast streams, and there's a huge push. But then who is driving it? It's an association. And that association is not just an individual. It's a group of people who have said, okay, we're not going to be selfish. We're going to work together to come up with something that will push our own agenda. So I'd like to see a conversation around how our copyright law can address some of these realities. There's a copyright bill that I think was cleared in the Senate. Unfortunately, I think the bill started more than the origin of the bill is about the bill got live or came to life more than 10 years ago. And you and I will agree that the realities of 10 years ago in terms of technology, where technology has come to, are not the realities of today. So it will be good to have this conversation. Let's see how we can drive it and also affect policy while we learn. So once again, well done. Thank you very much. Kindly pardon my
Thank
rant
you so
now.
much, Mr. Folari. Thank you so much for your words of wisdom and for the experience that you've brought to the discussion today. We're so grateful. So I've just checked and Zerona is not here. So when she joins us, she'll be able to also give her comments. But we're going to go straight to answering questions. So we have some questions. I'll just read out the questions. And so the first question is, are there exemptions or defenses to copyright claims? If yes, what are they and how can they be enforced? So let's hear from Bernice. Okay, she was talking about her her device going off soon. So I'm not sure if she's still with us. Okay, it's possible she's not here. Okay, so let's hear from Mr. Folarin, please. Are there exemptions or defenses to copyright claims? If yes, what are they and how can they be enforced?
Fantastic question. There are, so I'll reframe the question. The question is, what are the defenses to copyright infringement claims? And yes, there are defenses in Nigeria. There's the first defense, I think, is contained in Section 1 of the Copyright Act. And that's the defense of concurrent creation. So copyright, with the purpose of copyright, well, the objective of copyright law is to stop the unauthorized or unlawful copying of the work. And so, funny enough, you can have a situation where two people, independent of each other, will create the same or very similar works. In that sort of situation, there's the likelihood that one person could claim, oh, this person infringed my copyright in X, Y, Z. But a claim of copyright infringement essentially means that somebody copied, or in Nigeria, that the individual flouted any of the, or committed any of the acts described in Section 15 of the Copyright Act. So the first, but if you look at Section 1 of the Copyright Act, that section provides that a work that, and I'm paraphrasing now, that copyright, the fact that a work infringes on the copyright of another does not mean that that work will not enjoy copyright protection. So, and that's just speaking generally. So the first defense is that there was no copying. You also have concurrent production or concurrent creation. You have the defense of innocent infringement. So there's a defense that the infringer infringed, but the infringement was done innocently. And if you look at, I think it's still the same Section 15 Section 15 sub 4, I think, of the Copyright Act, that then goes further to say, in a situation where there's innocent infringement, I think what the copyright owner is entitled to an account for profit. And in that case, the court would not award punitive or exemplary damages. So that's one of the implications. Then you have the doctrine of, is it fair use now? Fair use. There's a distinction between how the doctrine operates in Nigeria and how it operates in the US. But that's also a possible defense. And then, of course, justification of the existence of a license is a defense. I have an interesting case I participated in, and I find this happens in the broadcast industry a lot. Now, for example, MultiChoice is a company that provides DTH services, direct to home satellite broadcast services. Now, MultiChoice as a company has a platform called DSTV. And DSTV is a network of different channels. Each channel is owned by, some channels are owned by the network, by DSTV, some channels are owned independently by third parties. Now, certain channels, all the channels get their own content. Some licensed content from MultiChoice, some from other third parties. So you have a situation where Channel X, shows a movie that belongs to, Chinedu, for example. And then Chinedu decides, without obtaining a license properly or without, proper documentation or proper consent being obtained. But then Channel X is on DSTV, the network. So Chinedu decides to sue DSTV because DSTV, of course, is the big fish in the pond. And then you have a situation where Chinedu sues DSTV for copyright infringement, and sometimes they not even sue the Channel X, for the infringement. But then you find that what MultiChoice has evolved or has started to do, has done for a while now, is that in the release forms or content agreements between the network and the channels, there's an indemnity clause. And then, of course, with channels, most of the channels also put indemnity clause or indemnification clauses in the agreements that they sign, or the release contracts, or whatever type of agreement they sign, with those who supply content to them as well. But in that sort of situation, you can see it's very clear that the person who is being sued, because everybody looks at DSTV and says, oh, it's MultiChoice. My film was shown on MultiChoice, but it wasn't really shown on MultiChoice. It was shown on a channel, shown by a channel on the MultiChoice network. So there's always that danger of identifying, or picking the wrong person, identifying the wrong person. I read through, this was a while ago, it was a Kosan case. I read through the briefs where the suit was against a hotel. And the basis for that suit was that while this person was person booked a room in the hotel, and while in the hotel, some music was played on a channel, Channel O, on a particular channel, Channel X. I used an alphabet, not Channel O particularly, but on a Channel X or Channel A or Channel Y. And the channel was playing on a TV that belonged to the hotel. So therefore, the hotel had infringed on the copyright of COSON members. That's a very hard stretch. So in that case, of course, is the person who is being accused of infringement the infringer. So I would say that yes, they are different. I think I have gone around a little, but in a short answer to the question, there are exemptions to. The law provides for exemptions, the issuance of compulsory copyright licenses. The Copyright Commission can make arrangements or can compulsorily acquire or can issue compulsory licenses of the person's copyright in a work to third parties for reasons listed out in the Copyright Act. Of course, when that is done, I believe section 44, 45, section 45 of the Constitution will come into play. Section 45 provides that for reasonable compensation, stops the federal government, state governments from unlawfully acquiring the property of any individual. Because I think Article 14 of the African Charter on Human and People's Rights also recognizes the rights of Nigerians, because it's been domesticated, as the rights of Africans to own movable and immovable property, which includes intellectual property as well. So there are situations under which exemptions exist and defenses exist. Exemptions are different from defenses. Of course, once the once copyright in a work lapses, then the work falls into, just as I think I heard Zerona say, she was talking about public domain. Yes, and in terms of defenses, again, the Act provides quite a number of defenses: innocent infringement, fair use, justification, the existence of a license, so on. I don't know, I hope I have answered.
Thank you, sir. You have actually. Thank you very much. So I'll just go ahead to read the second question. How is the requirement of originality measured or determined for intellectual property protection? What are the ways? Okay, yes, so that's the second question. How is the requirement of originality measured or determined for intellectual property protection?
Oh, originality, I remember Faith sang a song, Originality. I should also mention, there was the last part of that, the first question talked about enforcement. In Nigeria, the Copyright Act provides for copyright inspectors. And also, I think to a large extent, the Nigerian police force is responsible for enforcing the provisions of the Copyright Act. In the US, the FBI does a lot of that. The FBI is primarily responsible for dealing with the enforcement part of copyright infringement and infractions. And then coming to the question of originality, and not Phase's originality. Sure, I feel so old. I feel I might be the only one. Juliana is smiling, so I'm guessing you know the song too. I hope you know the song. Originality by Phase from the Plantation Boys.
Please sing it so that we'll know the tune.
No, you want to embarrass me. Originality. Anyway, the originality means different things. When you're talking about originality in IP, it means there are so many contexts, but I would assume that we're talking originality with regards to copyright. And originality with regards to copyright speaks to the origin and not necessarily the novelty. So there's the concept of novelty that is distinct from, origin. You can talk about novelty as in something that is new, and that speaks to some of the requirements for patentability. Must be new, capable of industrial application, and the inventive step. But when talking about copyright protection, that originality requirement really speaks to the origin of the work, as opposed to the idea that the work must be something that did not exist before. So the originality requirement really is about where did the work originate from. And that is why you can have a situation where the copyright law protects the rights of two individuals who have created very similar sounding or similar looking works independently of each other. The objective of copyright law is to primarily discourage unlawful copying, So the originality function does not necessarily mean that the thing must be new in the sense that it never existed before. So I think if we're talking about the boundaries of originality, I think that's a good starting point, that the work must originate from that individual and must, to a large extent, when talking about that origination, it doesn't necessarily mean that everything must have come from nowhere. For example, there's this famous quote or famous aphorism among IP practitioners that A Tale of Two Cities, it was the best, as Mark Twain, it was the best of times, it was the worst of times. Now, that was a masterpiece, yeah? But the words that were used in putting that novel together, in writing the book, are words that already exist in the English language. So Mark Twain didn't have to invent new words to write the book. And the same thing goes for practically every expression. As is famously said in the book of Ecclesiastes, in the Bible, that there is nothing new under the sun. So the originality concept, I hope I'm speaking to the answer. It really talks about the origin of the thing. And so the question is, how do you determine that this work originated from this person? There are quite a number of ways. There's what used to be called poor man's copyright, which was a process by which an author of a work or a producer would copy their work and then mail it to themselves, so that the mail room or the post office will stamp a date on the parcel, which will then be proof or evidence of at least when it was created or when it was mailed. In practice, however, there are many ways to tender evidence. I'm speaking as a lawyer now. There are many ways to tender evidence to establish that one actually created this work as at this or that time. And one of the ways is to have other people in the room, to have other people who can testify that, yes, this person actually created this work. Yes, this person actually did this or did that. Another way is for the music people, to use, there are quite a number of tools that one can use, whether, at pre-production, post-production, to capture who worked on what and who did what in a particular song. And then, of course, in other areas, agreements, very important. So agreements tend to define, who did what and who is responsible for what, in joint, where they are joint efforts, I think. So these are very obvious ways of proving or establishing originality. Because if you're asking how do you determine it, the only way you can determine it is by, I'm assuming a dispute has arisen. The only way that you can determine that something originated or that a work originated from someone is by providing evidence, either independent evidence or actual, circumstantial evidence. In Nigeria, copyright is formality free. So registration is not a requirement to enforce one's copyright against another person. This is different from the situation in the United States, where copyright is formality free for the purposes of using the copyright, but for the purposes of enforcing infringement or potential infringement, one must have registered that copyright for the cause of action to arise.
Thank you, sir. Okay.
Thank you.
Thank you, sir. Sorry, it's hung for a while. There's a question. So I think that we'll be rounding up soon, but there's a question on sampling here. Please shed more light on IP law and sampling in the music industry. Question and round up.
Okay, IP law and sampling. I think that is an ongoing conversation, but IP law generally frowns on copying. And sampling really is copying to a large extent. So I would refer you to the Robin Thicke case, the Bloodlines case, and in that case, the two songs sound quite different, unless you are a music aficionado. But Robin Thicke came out and said, oh, that the inspiration for the work came from Marvin Gaye's Got to Give It Up, and he kept saying that. And so by the time the family listened and by the time the estate got wind, there was a huge row and then a lawsuit was filed. And it turned out that the beat pattern from Bloodlines sounded very similar to the beat pattern in Marvin Gaye's work. That wasn't sampling. That was a situation where there may have been some copying, but sampling implies that a work is taken, and Kanye, famous for bringing sampling into the mainstream of R&B. But sampling, I think, involves taking a work and then altering the work in a particular way. So it could be by removing the beats, removing the vocals, speeding it up, chopping it up, and then remixing it. And sampling has always been a huge part of hip hop culture. I know hip hop culture is actually is a form of counterculture, you know, so which is some kind of rebellion against the system. And so, with regards to the general attitude of IP law towards sampling, I think to a large extent you find that in hip hop circles, there's always some kind of copyright arrangement. You know, rights actually are discussed and agreed upon before the work is released. Unless, of course, the work is released as a mixtape, in which case there's always the argument that, oh, the mixtape is done for the art or for the beauty of the art and not necessarily for money. So mixtapes are released, they're not sold, they're just released, and it's done for, you know, to promote the art. Lil Wayne is very, very famous for releasing mixtapes almost, you know, after the albums come out, you know, remixing the entire albums and doing his own takes on the songs. So I think that there's this Kanye West Through the Wire. Kanye West Through the Wire was, I watched an interview of I forget her name now. Was it Chaka Khan? I forget her name. The lady who sang Through the Fire, which was the album or the song that Kanye West Through the Wire was based or built upon. And she said she actually didn't like, the interviewer asked her, "Oh, did you like, you know, Kanye's Through the Wire?" And she said no, she didn't like it. She felt, you know, he botched her song up, that she is more of a full music person and not necessarily a hip hop person. But but Kanye got permission from her through her son, and, you know, I think all the rights and royalties were paid properly. When that doesn't happen, then you end up in the situation that Robin Thicke, Pharrell Williams, and co found themselves in, where, you know, the courts actually awarded damages against them. I think there's a more recent, the Katy Perry case is a more recent example of not necessarily sampling, but, you know, some kind of light copying. And it had to do with, I think, the song Dark Horse. It was Katy Perry and a gospel artist, I forget his name now. So how does IP law respond to sampling? Is copying. You know, it's copying with some alteration. And of course, all the rights must be or should be properly obtained before any type of copying is to be used, especially if it's done for commercial purposes. When used for the purposes of, you know, advancing the art of a mixtape, there's a general acquiescence to that, okay, this isn't done for profit. And so you can say it will fall under some of the exceptions, educational use, or, you know, non-commercial use, private non-commercial use, which, you know, skipped my mind earlier, is one of the exceptions to a defense to a claim of copyright infringement. Are we still there?
Yes, sir.
Yes,
Yes,
sir.
sir.
Yes, can we?
Okay. So yes, I think that would, I mean, I have more thoughts, but I wouldn't want to. There's sampling, and then there are covers as well. Juliana will tell us a lot about covers. I'm quite interested in how, you know, our laws will respond to covers, because covers are a big deal. A lot of people come to light, especially with the advent of TikTok and of course Instagram and co. Many people have become famous. Omegle, or how is that pronounced? You know, and other social networking apps. Many people have become famous and popular just by doing covers of the songs of famous people. You know, and YouTube's response to that is actually to give almost 100% of the income to the original owner. You know, that's for YouTube, but YouTube has a very strict, a very hard stance on copyright infringement. They have a very strict policy, but there are different social media platforms that treat some of these things. SoundCloud, for example, treats this slightly differently, or quite differently, I think, from YouTube. And then now you have Rumble, and you have a couple of other social media sites. Well, Facebook definitely I haven't really studied the monetization process on Facebook, and to know whether Facebook uses the ISRC number to locate the original song and then pay royalties to that copyright owner. But I know that YouTube does that, largely. Uses the ISRC, the code to locate so the algorithm locates the original owner. I know Instagram used to do that. There was a time if you posted a video with the song of an artist on Instagram, it would the algorithm would automatically mute the song or take that video down. But nowadays you find there's a lot more. I think more artists are on Instagram. A lot of people use Instagram to promote their music. I think Instagram also has signed on to agreements with many CMOs, as collective management organizations. So I guess they have more access to more IP licenses to use different people's music, or to allow users use music on the platform without offending anybody's sensibilities.
Thank you very much, Mr. Folarin, for the contribution, and a big thank you to all the mentees and to all the mentors also. So Benny's phone was down, and so she had to leave. Zerona, I think she's having network issues. But to the last question, I'll just say that there's a difference between sampling and cover songs. So for cover songs, there can be compulsory licenses, but for sampling, it would have to be a voluntary license, and it's a derivative work. So if you look at the Copyright Act, there's a provision for derivative works. So it will fall under a derivative work, and you will not be able to get a compulsory license for that, but you'll be able to get a voluntary license. So you would talk directly with the owner of the work, and then the person would either agree or not agree. And if the person agrees, then you enter into an you get a contract for it, and you follow the terms of the contract. So with that, I would like to say a very big thank you. I know that the session today dragged, but it was because of the network that a lot of people, the network issues that a lot of people had, and also the fact that we treated a lot of topics, because we would like to just finish up with the IP for creatives. So with that, I would like everyone to kindly put your cameras on. Let's take a picture. Please write what you learned, and write what you learned on LinkedIn. Yes, I can see my people already. Write what you learned on LinkedIn, tag your mentors, appreciate them. So let's see your game faces. So while we are taking our pictures, please, while we are taking our pictures, please ensure that you cooperate with your teammates. Prepare, if anyone is discouraged, encourage them to continue so that we can finish strong. With that, I would like to thank everyone. Thank you, Sumibola Onifade. Thank you, James. Thank you, Jeremiah. Thank you, Olua. Oh, thank you, Esther. Thank you, Folakumi. Mr. Folari, please put your video on so that we can take a picture with you and post about it. Yes, so we're taking a picture with our mentors and we're posting about it on LinkedIn and thanking them. Okay, so I'm sure that we're able to take a picture with him anyway while he was talking. So thank you, everyone.
I had derobed. I started to disrobe.
Oh, sorry about that.
Yes.
Next time. Okay, but
so my camera. Hold on, you made me robe again. So
sorry, sir. So the videos are actually on YouTube and they're also on Facebook. So in case you want the robed version of Mr. Folari, you can just go take a picture and then oh, he's here. So please take a picture of our mentor's face, post about him, post about what you've learned, Zerona, Bernice, put it online. tag them, say what you learned, and then appreciate them. So thank you, James. Thank you, Oluwatosin. Thank you, Sumibola. Thank you, Esther. Thank you, Adebimpe. Thank you, Mr. Polari, and every other person. Take care of yourselves. Love you all. Have an amazing weekend. Bye.
Thank you now. Bye.
Bye.